would be heard in the order requested by each party. The parties were required to submit by the 18th of November 2025 a written affidavit for each of the individuals they intended to call as a witness at the hearings. The Gambia was also required to submit a written statement by the expert it intended to call to testify. The parties were also requested to provide, by the same deadline of the 18th of November 2025, unredacted copies of any previous statements or accounts given by the witnesses or expert called to testify during the oral proceedings, which have been annexed to their pleadings in redacted form. The letters underscored that the unredacted version of the affidavits, written statement of the expert, and prior statements or accounts provided by each party would be communicated to the judges and the other party, but would be treated as confidential and would not be made public, available to the public. By letters dated the 13th of November 2025, the Deputy Registrar informed the parties of further decisions taken by the court concerning the procedure for examining the witnesses and the expert called by them. The parties were thus advised that after making the solemn declaration provided for in Article 64A of the Rules of Court, each witness would be asked to confirm his or her written affidavit, and if applicable, any prior written statements or accounts annexed to the written pleadings, subject to any correction the witness may wish to make. The calling party would then proceed to its direct examination, which would take the form of replies by the relevant witness to questions put to him or her by counsel. This would be followed by cross-examination of the witness by the other party, which would be confined in scope to written and oral statements already made as part of the witness evidence in chief. A re-examination by the calling party would then be possible, limited to matters having arisen as part of the cross-examination. The expert called by the Gambia would be asked, after making the appropriate declaration in accordance with Article 64B of the Rules of Court, to endorse his written statement as well as his earlier reports annexed to the Gambia's written pleadings, subject to any correction the expert may wish to make. The written statement and reports would constitute the expert's evidence in chief and serve in lieu of his direct examination at the hearings. This would be followed by cross-examination of the expert by Myanmar, which would be confined in scope to statements already made by him as part of his written statement or reports, and re-examination by the Gambia, which would in turn be confined to matters arising as part of the cross-examination. Following re-examination, question could be put to the relevant witness or expert by the President on behalf of the court or by individual judges. The witnesses and expert would respond orally and without delay to any question put by the parties or by the judges, except in particular circumstances, for example, when specific information was requested that needed to be verified. In order to ensure the safety of the witnesses called by the parties, the court decided that they would be heard in closed sessions, with only judges, registry staff, interpreters, technical personnel, and members of the delegation on the official list provided by each party to the court being allowed in the courtroom during the in-camera sessions. The parties were also informed that the court had agreed to the use of pseudonyms when addressing the witnesses called by the parties or when referring to them at the hearings. By a letter dated the 18th of November 2025, the Gambia provided written affidavits of its witnesses as well as the written statement of its expert. By a letter of the same day, Myanmar informed the court that it intended to call only one witness and reserved the right to call a different witness if for any reason the former should be unavailable to testify. Myanmar also provided confidential written affidavits for both of these witnesses in the Myanmar language, accompanied by certified translations into English. It further indicated the pseudonyms that should be used for these two witnesses. After ascertaining the views of the parties, the court decided, pursuant to Article 53, Paragraph 2 of its rules, that copies of the pleadings and documents annexed in their redacted versions as appropriate will be made accessible to the public on the opening of the oral proceedings, except for certain annexes that will be kept confidential. In addition, with regard to written pleadings and documents annexed, which contain written statements and accounts given by the witness called by the parties, as well as the redacted version of the affidavit of witnesses and the verbatim record of their testimonies, it was decided that these materials would only be posted on the court website after the end of the oral proceedings. The court also decided to make accessible to the public, on the opening of the oral proceedings, the reports submitted by Myanmar on the measures taken pursuant to subparagraph 4 of the operative clause of the Order on Provisional Measures of the 23rd of January 2020, and the Gambia's comments on them. In this respect, the court notes that the parties were consulted on this matter and did not object to such publication. Further, after consulting the parties and the intervening states, the court decided to make accessible to the public, on the opening of the oral proceedings, the written observations of the parties on the declarations of intervention pursuant to Article 83, Paragraph 1 of the Rules of Court, the written observations of the states seeking to intervene, and those of the parties on the admissibility of the declaration of intervention in accordance with Article 84, Paragraph 2 of the Rules of Court, as well as the written observations of the intervening states referred to in Article 86, Paragraph 1 of the Rules of Court on the subject matter of their intervention. I note the presence in the court of the agents and counsel of the two parties. In accordance with the arrangement for the organization of the proceedings which have been decided by the court, the hearings will comprise a first and second round of oral argument. The first round will begin today with the oral pleadings of the Gambia and will close on Tuesday, the 20th of January 2026, following Myanmar's first round of pleadings. For the first round, each party will have 6 sessions of 3 hours at its disposal. The second round of oral argument will begin on Monday, the 26th of January, and conclude on Thursday, the 29th of January. Each party will have 3 sessions of 3 hours to present its reply. In addition, the court will hear witnesses and experts between the two rounds of oral argument. The witnesses of the Gambia will be heard in 3 closed sessions on the morning and afternoon of Wednesday, the 21st of January, and on the morning of Thursday, the 22nd of January. The expert called by the Gambia will be heard in open session on Thursday, the 22nd of January at 3 p.m. The witness called by Myanmar will be heard in closed session on the morning of Friday, the 23rd of January, 2026. In this first setting, the Gambia may, if required, avail itself of a short extension of time in view of the time taken up by my introductory words. I now give the floor to the agent of the Gambia, High Excellency Mr. Dawda Jallow. Sir, you have the floor.
Mr. President, esteemed judges, it is an honor to address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. 6 years ago, the Gambia filed its application with this court, seeking to hold Myanmar accountable for its violations of the Genocide Convention. In January 2020, you ordered provisional measures and did so unanimously. We are now finally in the merits hearing, after which the court will decide whether Myanmar is responsible for acts of genocide against the Rohingya group, as alleged by the Gambia. As you will hear over the next 3 weeks, and in particular over the next 4 days, in deciding to bring this case, the Gambia acted on the basis of most careful reflection and assessment of the facts. We did not bring this case lightly. We brought this case after reviewing credible reports of the most brutal and vicious violations imaginable inflicted upon a vulnerable group that had been dehumanized and persecuted for many years. We received and carefully examined the meticulous reports of the United Nations fact-finding mission, dispatched by the UN Human Rights Council. We also examined reports issued by the reputable international human rights organizations, which sounded the alarm on the genocide of the Rohingya unfolding in northern Rakhine State. Those credible reports from diverse and independent sources left no doubt in our minds that Myanmar had to be held accountable for its violations of the Genocide Convention. And so we acted. Genocide Convention is the first multilateral human rights treaty that have been adopted. But its words will be meaningless unless they are acted upon and enforced. It is up to the state parties to the Genocide Convention to invoke affirmatively its provisions in order to truly liberate mankind from the odious scourge that is the crime of genocide. That is why the Gambia invoked Article 9 of the Convention and brought its dispute with Myanmar to this honorable court. The Gambia stands tall in the international community of states and takes pride in promoting and protecting human rights, including international accountability for genocide and other atrocity crimes. We do this out of sense of responsibility, grounded in the history of which we too suffered under a military junta. Over 2 decades of brutal dictatorship have taught us that we must use our moral voice in condemnation of oppression, of crimes against individuals and of groups, wherever and whenever they occur. It is also taught to us that accountability is imperative. Otherwise, impunity will ensure that such crimes are repeated over and over. In present times, these issues are more important than ever. And the court's role is more important than ever as a bastion for the rule of law. Sadly, Myanmar appears to be trapped in a cycle of atrocities and impunities. Nobody has been held responsible for the crimes against the Rohingya. Indeed, the military that perpetrated the genocide actually felt emboldened to overthrow the civilian authorities again. Myanmar's original agent in this case, the former State Councillor, Madam Aung San Suu Kyi, has been imprisoned by the military junta, deprived of her liberty since she was swept from power by the same generals who continued to rule the country. And Senior General Min Aung, who commanded the military during the genocide, now rules over Myanmar as the leader of the junta. Predictably, violence and atrocities have spread throughout the country, affecting Myanmar nationals of all ethnic groups. Mr. President, while Gambia is the only applicant state, we are not alone in this cause for justice and accountability. Indeed, as the General Assembly stated in 1946, genocide shocks the conscience of mankind and results in great losses to humanity. And this is because humanity, our shared humanity, is made of various groups protected under the Convention. This is why we stand before you with full backing and support of 57 member organizations of Islamic cooperation. We also stand in solidarity with 11 intervening states from across the world who have urged the court to interpret the Convention in a meaningful way in the manner advanced by the Gambia. We stand too with the support of dozens of international human rights organizations and defenders whose investigations and reports have corroborated the findings of the UN fact-finding mission and its successor, the International Investigative Mechanism for Myanmar. And most importantly, we stand together with and for the Rohingya survivors of Myanmar genocide. This group of Myanmar nationals have endured decades of appalling persecution and years of dehumanizing propaganda. This culminated in the savage genocidal clearance operations of 2016 and 2017, which were followed by continued genocidal policies meant to erase their existence in Myanmar. We are proud that, once again, Gambia's delegation includes several members of the Rohingya community, including those who have traveled from the refugee camps in Bangladesh to be with us at this hearing. I invite them to stand so their presence may be acknowledged. Thank you. I turn to the case. It is not about esoteric issues of international law. It is about real people, real stories, and real group of human beings, the Rohingya of Myanmar. They have been targeted for destruction. They are farmers, laborers, teachers, mothers, fathers, sons, daughters, grandparents. They are ordinary folk. They have dreams and aspirations like all of us. And first and foremost, it is the most simple dream to be able to live in peace in their homeland under conditions of dignity and security. Myanmar has denied them that dream. In fact, it turned their lives into a nightmare, subjecting them to the most horrific violence and destruction one could imagine. 3 of the Gambia's witnesses, who will testify in closed sessions next week, have to endure that nightmare personally. They are first-hand eyewitnesses to the clearance operations that took place in 3 of the villages that were focused on by the UN fact-finding mission namely Minji, also known as Tulatoli, Chutpin, and Muanu, also known as Monapara. All three of them lost family members in genocide. For their safety, we will only refer to their initials when we reference their written and oral testimony in these oral proceedings. Mr. President, members of the court, the Gambia has carefully examined jurisprudence and has fit this court's jurisprudence and has fit its case within that legal framework. There were genocide acts and there was genocidal intent. During the clearance operations in 2016 and 2017 and subsequently. This is evident based on particular circumstances in many villages and Myanmar's overall pattern of conduct. The Gambia believes that the evidence that has been submitted to you and which you will hear described this week admits of only one reasonable inference in regards to that pattern of conduct, that Myanmar acted with intention to destroy the Rohingya as a group or in whole or in part. The Gambia is proud to be represented by a diverse and talented team of international advocates who will present all aspects of the Gambia's case. 5 of them, including 2 Gambian state attorneys from my chambers, will be pleading before this court for the first time. After me, Professor Philip Sands will introduce the legal context for this dispute. He will be followed by Paul Reigler, who will provide an overview of the Gambia's case in the context of the court's previous 2 genocide cases, and that is Bosnia, Serbia, and Croatia, Serbia. Mr. Aslan Suleiman will then provide an overview of the relevant geography, demography, and history of the Rakhine State and discuss why the Rohingya are a protected group under the convention. In the afternoon, Mr. Reigler will return. In the afternoon, Mr. Reigler will return to discuss the quality and reliability of Gambia's evidence in this case. Then Mrs. Tafagwa Pasipanodia will present the history of discriminatory laws and persecution of the Rohingya in Myanmar, which is one of the indicators of Myanmar's genocidal intent. Mr. Suleiman will return to discuss another of such indicators, Myanmar's year-long efforts to disseminate anti-Rohingya hate propaganda. On Tuesday afternoon, Mr. Andrew Lewenstein will provide an overview of Myanmar's anti-Rohingya clearance operations and discuss how their organized nature and execution constitute another indicator of Myanmar's genocidal intent. Our presentations will continue with 4 speakers who will provide detailed presentation on the clearance operations in specific locations. Ms. Pasipanodia will discuss Myanmar's genocidal attack in Minchi or Tulatoli. Ms. Jem Hong Ho will present on Myanmar's genocidal attacks in Chut Pien. Ms. Mariam Angom will examine Myanmar's genocidal operations in Muangnu or Monu Para. And Mr. Charles Kombenjai will describe Myanmar's genocidal attacks in other notable villages. On Wednesday morning, Ms. Ho will discuss how the extreme brutality of Myanmar's clearance operations evidence Myanmar's genocidal intent. Ms. Pasiponodia will then focus on why the pervasive sexual violence during Myanmar's clearance operations indicates its genocidal intent. She will be followed by Mr. Lowenstein, who will demonstrate that Myanmar's targeting of children is also an indicator of its genocidal intent. After that, Ms. Yasmin Alamin will demonstrate that Myanmar's destruction of evidence is also an indicator of its genocidal intent. And Professor Per Dazin will conclude the morning session with a presentation on Myanmar's pervasive impunity and how that also reveals its genocidal intent. On Wednesday afternoon, Mr. Suleiman will show that Myanmar's argument that its clearance operations were ARSA counterterrorism operations is not a defense to genocide because the evidence fully established that the manner in which these operations were organized and executed contradicts every tenet of counterterrorism doctrine, including Myanmar's own. Mr. Lowenstein will then demonstrate how the evidence described by the previous speakers Mr. Lowenstein will then demonstrate how the evidence described by the previous speakers demonstrates Myanmar's commission of the actus reus of genocide under Article 2 of the Convention. He will be followed by Professor Sands, who will highlight proof that Myanmar acted with the requisite mens rea or dolus specialis of genocide, and that's its intent to destroy the Rohingya as a group, in whole or in part, is a manifestly reasonable inference to be drawn from that proof. Ms. Reichler will conclude our presentation on Wednesday by showing that genocidal intent is the only reasonable inference that can be drawn from Myanmar's pattern of conduct across the clearance operations, and specifically that the evidence demonstrates that it would be entirely unreasonable to infer that the intent of Myanmar's targeting, mass killing, maiming, raping of many thousands of unarmed and defenseless Rohingya civilians, including pregnant women, children, the elderly, and the infirm, as well as burning of their houses and razing of their villages, was to combat terrorism. On Thursday, in our final session, Ms. Jessica Jones will discuss other breaches of convention for which Myanmar is legally responsible. Mr. Suleiman will examine Myanmar's breaches of the court's provisional measures order of January 2020. Then Professor Dezan will present the remedies requested by the Gambia. And finally, Professor Sands will conclude our opening presentations on Myanmar's commission of genocide, on the witnesses you will hear, and on the significance of this case. The Gambia will present one additional witness, Professor Michael Newton, who will testify in open session next week. Professor Newton is a former military officer who specializes in the laws of war and counterterrorism operations. His testimony will demonstrate that Myanmar's clearance operations cannot be reasonably explained by the intention to counter terrorism. Rather, the only reasonable inference that can be drawn from its conduct is an intention to destroy the Rohingya group as such. Mr. President, honorable judges, these oral hearings come at a time in which the fundamental principles of international law, as enshrined in the UN Charter, are under stress and threat globally. Many have lost faith in the promise of international law. Many are looking at this case to see if the Genocide Convention is more than just words on paper. We are confident that this court, the principal judicial organ of the United Nations, will stand in the breach and uphold the rule of law, which epitomizes our collective conscience. As the guardian of our moral and legal compass under the Genocide Convention, we come to you because this court is the only hope for justice and accountability that the Rohingya and all people of Myanmar so greatly deserve. Mr. President, members of the court, I thank you for your courtesy and for your keen attention to this case and for allowing me to address you. With your permission, I would ask that you call Professor Sands to the stand. Thank you.
I thank His Excellency Mr. Daud Jallow. I now invite Professor Philip Sands to address the court. You have the floor, sir.
Mr. President, members of the court, it is an honor to appear before you on behalf of the Gambia in respect of this application under the 1948 Genocide Convention. The importance of this case in relation to the protection of the Rohingya community in Myanmar and more broadly, and the importance of the issues before you at a time when the international rule of law is under grave threat are plain. This morning, I'm going to address the beating heart of this case, the meaning and effect of the Genocide Convention. How the court approaches this will determine how the Gambia's application is decided. And as you well know, the Convention is of singular importance in the history of modern international law. Adopted in 1948, very largely as a result of the efforts of one man, Raphael Lemkin, it was the first modern human rights treaty to be adopted after the horrors of the Second World War. It is emblematic. It is emblematic of who we are, of who we wish to be, of how truth and law are to address matters of raw power. If the Convention is diminished, then we are diminished, and the values that were articulated in that extraordinary post-war moment are diminished. The protections provided by the 1948 Convention have been addressed by this court on several occasions. These previous judgments inform how it is to be applied in the case of the Rohingya, and my colleagues and I will draw on these sources, guided by the rulings of this court, as well as judgments in genocide cases before other international tribunals and increasingly before national courts, in respect of the points that I make in this submission. Mr. President, it's to be emphasized from the outset that there are many aspects of the legal framework which are not in dispute between the parties. Myanmar and the Gambia agree on certain aspects and what the Convention says about them, but there are important areas of disagreement. And in respect of these areas of disagreement, the Gambia and all 11 of the intervening states speak with one voice on how the Convention is to be understood, consistent with the history, the context, the object and purpose of the Convention, as this court has interpreted and applied it. That united interpretation is, we say, important, for it highlights that where Myanmar's interpretation diverges, as it often does, it is a solitary expression of dissent. I'm going to proceed this morning as follows. First, I'm going to address the context and negotiating history of the Genocide Convention. Second, I'm going to identify key aspects of subsequent practice under the Convention, which elucidates the approach we invite the court to take. Third, I'm going to set out the significant points of agreement between the parties and the interveners on key provisions of the Convention. Fourth, I'm going to address the key components of genocide, namely the relevant actus reus and mens rea. And fifth, and finally, I'm going to address other aspects of the legal framework to be addressed by my colleagues in due course over the next 4 days. Start with the context, the negotiation of the Convention. Mr. President, Raphael Lemkin invented the word genocide. He constructed that word out of the Latin and Greek words genus and side, to mean the killing of a group or of a people. And here you can see the word in his own writing on the screen, a document that may be found in the Rare Book and Manuscript Library at Columbia University in New York City. He chose the word genocide as the title for Chapter 9 of his book, Axis Rule, which was published in November 1944. I've taken the liberty of bringing a copy of the first edition of that book, my own copy, to court today. As you'll see, it is personally inscribed by Raphael Lemkin in the Nuremberg courtroom on the 4th of July 1946. This room today is in direct connection with Courtroom 600 and the Palace of Justice. And I invite you, please, to read all of Chapter 9 of that book. It's not long. It's available online. As you read Lemkin's words, I suspect, like me, you may be